Bruchim Aboim B'Shem Hashem, B'Shem Irgen Shir Moses Boston. I'd like to welcome everyone to tonight's shir from Rabbi Ari Marburger, Shlit. I'd like to give a big yashikayach to sponsors of tonight's shir. I'd like to give a yashikayach to Rabbi Ari Parnas, one of the board members of Irgen Shir for sponsoring tonight's shir. We'd like to give a big yashikayach to the Lowinger family for their support for tonight's shir. Will In Halacha, Isha Mindel, Masha Bosher, Allah Shalom Yotzai Tezayin Ov. I'd like to give a big yashikayach to Mr. and Mrs. David Lang, the support for tonight's shir, Will In Halacha, Oisha Chana, Bas Rabitzuk, Eliezer, Leah Sholem, Basir, regular Shloishim, there's the same Tzuris B'Tzor HaChaim. To have the great schus of sponsoring a shir, or putting an ad in the dinner journal for the upcoming annual dinner of Irgen Shir Torah, and have a chelik in our Botz's Torah, the Rabbim of Irgen Shir Torah. Call Irgen Shir Torah at 718-851-8651, or email ist@yeshivanet.com. Tonight we have the covered Hava with us, Rabbi Ari Marburger, Shlit Dayan and Bais in Maysharim in Lakewood, and the author of Business Halacha, to speak on the halachas of the will. So I covered the call on Rabbi Marburger for tonight's share.
Thank you. A young widow was up late one night preparing her house for Pesach. She had just recently lost her husband, who had passed away after a brief illness. It was quiet in the house. She was alone with her thoughts. And as she struggled with moving the oven, she noticed an envelope wedged behind. She pulls out the envelope. She sees there's a note from her husband. And it's addressed to her. And it says, "Dear Shprinza, if you're reading this note, it means that I'm no longer with you. I know how difficult it must be this first Pesach. And therefore, I want to cheer you to cheer yourself up a little bit, buy yourself something nice for Yontiv." And there were $2,000 of cash sitting in the envelope. You can imagine how touched she was. And the next day, on her way to the jewelry store, she was called her brother to tell him about what happened and how thoughtful her late husband had been. And her brother listened to the story and said, "Wait a second, not so fast. Who says this cash actually belongs to you? Are you so sure that you're entitled to spend it and buy yourself jewelry? We all know, as a matter of halacha, that children are the yarshim. Your husband left no will. There was a note. Is that a kinyan? Is that a tzava? Is that a legal will? Perhaps not. Perhaps the money actually belongs to your children. They're minors. They cannot even be meichel. So it may not be permissible for you to go buy yourself this piece of jewelry. This is a real problem in halacha." Now, before anyone gets too outraged about this story, let me assure you it never happened. But nevertheless, this anecdote illustrates a few points about Hilchos Yerusha. The first is what a person might want to happen to his estate. If he doesn't execute the appropriate will, the appropriate tzava, may not actually be enforceable or halachically permissible. It shows also that doing what seems fair and what's right may not be what's mutter or what is legal. It's two very, very different questions. It also shows that when it comes to Hilchos Yerusha and estate matters, it's almost never about the dollars alone. There's a lot of emotional baggage that comes along into any question, and preparing appropriately can save a tremendous amount of stress and agbas nefesh in the future. And lastly, perhaps it shows that you can have a terrible, heart-wrenching situation, which could have been completely avoided and resolved with just a little bit of planning and a little bit of foresight. So with that in mind, I'd like to spend tonight to walk everyone through some of the basics of Hilchos Yerusha. We'll begin with the Seder HaYerusha, what happens if a person dies intestate without any tzava or with any halachically binding will, how the estate is divided. We'll then focus a little bit about actual estate planning, the permissibility and how one changes the default Seder Yerusha in halacha. And we'll end off with just some practical advice on halacha l'maisa, things to keep in mind how when a person is setting up his estate to try to minimize machlokes. So let's begin with the Seder HaYerusha. If a person dies, he has no will, he has no tzava, he has no specific instructions. So halacha has a Seder HaYerusha, a way in which the assets are divided. Now before we go through what the Seder HaYerusha is, a brief comment about what it is not. It's not politically correct. The Seder HaYerusha is not consistent with Western liberal values. There's just no way around that fact. It's chukas mishpat. And in truth, whenever we come across a halacha that seems inconsistent with the values of the society around us, it certainly should give us pause about the real utility or the appropriateness of some of those values. But what's interesting is that the Seder HaYerusha has not been politically correct for at least 1,000 years. The Tshuvas Arash discusses a case where someone had asked him for help working out an estate plan that was different than the halachic default. Apparently back then, it was stylish to give everything to your bukhar, to the oldest son, and completely cut everyone else out of the estate. Kings or monarchs did not want that when they passed away, their kingdom would be divided among all their children. So they would give everything to the eldest child. He would become the king. He would usually wipe out the rest of the family. And there was no division of the assets. The Rosh was asked to devise a similar estate plan. And he writes in very strong language, I see that you're trying to copy the ways of the Gentile society around us. If that's your intent, I want to have nothing to do with this, and he declined to get involved and to assist in that estate planning. So what is the Seder HaYerusha? If a person passes away, in halacha, his sons yarshin the entire estate. If he has sons and daughters, it all is divided among the sons. Now, interestingly, a wife is not a yorish min haTorah. A woman does not inherit her husband. This is one of the most significant differences between the halachic Seder HaYerusha and lahavdil, the legal distribution of assets. But legally, a wife does yarshin a portion of it. There are statutory minimums. She cannot be cut out. As far as halacha, a woman is not a yorish. The converse, actually, if the woman predeceases the husband does yarshin her. But in general, as we will see, the Seder HaYerusha follows the male line. The assets generally stay within the shevet. So if a father dies, he leaves over sons and daughters. The estate is divided among the sons. Grandchildren receive nothing if their parents are alive. They're simply not Yershim. It goes to the sons. It's only if one or more of the sons predeceased the father, then that son's children will step in their place. Their Yershim will step in their place. But if the sons are alive, grandchildren do not receive anything. Grandsons? Well, it depends. If a person's son predeceases him, if he has sons, then the grandsons will yarshin. If he has only daughters, then that daughter will step into her father's shoes and receive a share of the estate. So, in theory, if a person has a son and a daughter, the son dies first and leaves over a daughter, that daughter will get the entire estate. Now, if a person dies without any children, without any sons and without any daughters, then the Yerusha flows up a generation. It goes to his father. If his father is no longer alive, then his father's Yarshim, his father's children, first the sons, if he has any. If he has no sons, then his daughters will step in their place. Will receive the estate. If the father has no Yarshim, In other words, the deceased has no brothers, sisters, nephews, or nieces, or anything of the sort. Then it goes up a generation to the grandfather. Grandfather presumably is no longer alive, but from the grandfather it flows to his Yarshim. So already we're dealing with cousins and second cousins, etc. Now, if you go up far enough, every Jew is related. If you go back to Yaakov Avinu, we're all distant cousins, and therefore eventually a Yerush will be found. So essentially, when a person dies, a wife is not Yerush. It goes to the person's sons are the Yarshim, or if he has no sons, it's his daughters. Again, if any of the sons or daughters predecease him, it goes to their children. If there are no Yarshim underneath him, it goes up a generation and then to the side, etc., until a Yerush is found. Now, one other important halacha is the concept of a bachar. If the firstborn child is a male, he's a bachar, and he was born naturally, someone who is born via C-section does not have a din of bachar lenachla, but a bachar lenachla receives a double share. He receives pishnayim, which means if a person has two sons, the estate will be divided into three portions. The bachar will receive two of the portions. The pashut, the regular son, will receive one of the portions. That means the bachar will get pishnayim. If you have three sons, you'll do the same. You'll divide the estate into four portions. The bachar will get two of them, or half of it, and the other two sons will receive the remaining half, 25% apiece. Now, this is the default Seder HaYerusha, if you will. Now, based on this, there is an assumption that if a husband dies, the wife is left penniless. She's not a Yerush. She receives nothing. Now, for a number of reasons, for a number of practical reasons, this is not true. And the reasons are as following. The first is, we're discussing Yerusha. When a person dies, he no longer, you don't take your wealth with you. The estates, the assets have to be divided among the Yarshim. And the Seder HaYerusha tells us who the Yarshim are. But many people, especially if they have a more modest estate, the bulk of their wealth will be tied up in their house, where they live. Many couples, their house is jointly owned by both the husband and the wife. If that's the case, they're partners in the house. 50% will belong to the husband, 50% will belong to the wife. This has nothing to do with Hilchos Yerusha. In such a case where the house is jointly owned, and we're going to assume it's a 50-50 partnership, then the wife is entitled to have 50% of the house, not as in Hilchos Yerusha, but simply because she is a partner in this asset. We're getting there. Okay. So that's why, in practical sense, as long as she's on the name. Now, there is sometimes a debate. Sometimes one spouse will say it was really my house. It was put under your name to qualify for bank financing, for tax reasons, whatever that may be. We have all sorts of interesting and somewhat acrimonious Dinei Torah about it. But the end result, or the default assumption, is this is going to be owned 50% by each, regardless of Hilchos Yerusha. Now, it's a matana, essentially, where it was put on, by putting it under her name, it's essentially giving her a gift of half of the house. Now, that's the house. What about the bank accounts? Many people have bank accounts, or their joint accounts as well. Now here, perhaps there's even a stronger argument, but the idea being that, first of all, by creating a joint account and depositing funds into this joint account, there's a very strong argument that essentially you're making both account holders partners in the funds. Now here it's a little bit different. They're in two ways. The first is, depending on which state you live in, it's not necessarily 50% belongs to the husband, 50% to the wife. It could be a tenancy in common, or where each of them owns the entire amount, in which case you can make the argument, and it's an account, really any account with rights of survival, the argument can be made that in such an account, when one person passes away, the account is structured where the entire account passes over to the survivor by operation of law. It doesn't go through probate. It's not, b'dinehem considered a form of Yerusha or inheritance. It's simply operation of law because that is how the account is structured to begin with. And therefore arguably, there is a kinyan mechayim to have that whoever survives will own the entire asset. On top of that, Chidusha Rabbi Shlomo makes a fascinating technical argument, and that is, when you own a house, that's an asset that belongs to the owner. Belongs to the husband, belongs to the wife, a partnership, whatever it may be. When you deposit funds in a bank, what you're really doing is you're lending the funds to the bank. Now, when you lend the funds to the bank, there are certain terms to this loan. And the terms of a joint account are that the entire amount should be paid to the surviving spouse. If that's the case, forgetting about Hilchos Yerusha, forgetting about whether there's a good kinyan, this bank, which for argument's sake we'll assume is a non-Jewish bank, took money and agreed to pay the surviving spouse the entire balance. They're going to do that, nothing to do with Hilchos Yerusha. And therefore, there's a strong argument that money in a joint account, certainly 50% will be hers. Arguably, if there are rights of survival, arguably she'll be entitled to the entire amount, regardless of the fact she is not a halachic Yerush. Now, a similar dynamic would come into play with life insurance. If a person buys life insurance, and let's keep it simple, we'll talk about term life insurance. So there, assuming the wife is the named beneficiary, Hilchos Yerusha is irrelevant. No one yarshins the death benefit. The death benefit is simply a contract that the insured pays the insurance company, and the insurance company contractually obligates themselves. Then, in the event of his death, they will pay this benefit to the named beneficiary. That has nothing to do with Hilchos Yerusha. So whoever is named as the beneficiary will be entitled to it halacha, regardless of whether or not they are classified as a Yerush. So the first point is, although people walk around with this idea that in halacha the wife is not a Yerush and therefore she ends up with nothing, for many, the way finances are structured in many families, she will, before you even begin discussing Hilchos Yerusha, she will be entitled to at least half and sometimes substantially more than the estate.
Even if there's a will? Even if there's a will to the contrary, specifying...
Well, to the extent that the house half of it belongs to her, you can write a will to give away your assets. You can't write a will how to give away your wife's assets. So to the extent that something belongs to her, a will not have the ability to change that. Now,
When a man, let's say, buys jewelry for his wife, how does that work with Mashakani Ishakana?
okay,
That
good.
diamond ring, who owns it?
Okay, good question. And if they get divorced, these are all sorts of dinei Torah.
The husband give a wife a gift, or
He could. No. He could. He certainly could.
goes back to the husband?
No. He certainly could. The question is whether that's the intent. If he gives her a gift and then they get divorced, sometimes he has a claim for it back. He gave it to her while they were married, but he certainly could. And if he does, then it's given. Now, okay. Now, what? Give a gift to his wife. Right. Now, this is the first point, that the way people's finances are structured, the woman usually owns a good chunk. But there's another point which also has a tremendous impact. And that is, we're all familiar with the concept of a ksuba. When you get married, there's a ksuba, which entitles the wife to 200 zuz if they get divorced or if she becomes a widow. However, there's another takana, and that is that when a widow is entitled to support from the estate until she remarries or claims the ksuba. Now, what that means is, in practice, although 200 zuz is not an awful lot of money, it's a question of exactly how you value it. $10,000 is probably is a rough approximation of what it is. That's if she demands the ksuba. If she doesn't ask for the ksuba, she's entitled to support from the estate. She's entitled to mezainis, she's entitled to food, entitled to a place to live, she's entitled to cleaning help, and she's entitled to some of her medical bills, refuah dein lekitzvah, and that ends up being a pretty substantial sum. So, although in Hilchos Yerusha she's not entitled, she doesn't yarshin the underlying assets, but nevertheless, she is entitled to lifetime support from the estate. And therefore, her needs are taken care of, even though, as a matter of halacha, she's not a Yerush. Now, in more modest estates, this will very often eat up the entire, if she survives him and she lives a while longer and she doesn't remarry, this will essentially eat up the bulk of the estate. But what really happens is that the woman is taken care of for life. Her needs are, almost all of her needs are covered. The only thing that she cannot do because she's not a Yerush is she can't give away the assets. The underlying assets aren't hers to start giving away to her favorite Einikel, giving away nice Hanukkah presents. So to the extent that she doesn't have assets, the assets were not under her name in her lifetime, and she's relying on support, she won't be able to give away the assets. If she gets remarried, she will not be able to take the underlying assets with her. But nevertheless, until she gets remarried, her needs are more or less taken care of from the estate, again, regardless of Hilchos Yerusha. So this is a good example of, while if someone opens up a chumash and just concludes that the wife is not a Yerush, she ends up penniless, destitute, and on the streets, in practice, because of the way things are set up, she will end up with a very large chunk of the estate. And what's fascinating is in more affluent estate planning, very often this is really what's set up b'dinehem. Money is put in a trust where the income is there for her support and maintenance, but the underlying assets are very often kept in the trust with the expectation or the idea that after she passes away or if she remarries, the bulk of the estate is still there for the testator's children and won't be passed along to a second marriage, if you will. Now, this is as far as the rights of a woman. The Bechor as well, in practice, is much less clear than it sounds like in theory. And that is, although a Bechor gets Pishnayim, although he gets a double share, that only applies to assets that are tachas, they're muchzik, they're tachas yada. He is in physical control of. On the other hand, an asset which is roi, which is its debt that's owed to him, that he'll receive in the future, there is no din of Pishnayim. Now, in practice, if the deceased had, diamonds or owns real estate, that's muchzik. That's a hard asset that he owns, and the Bechor would be entitled to Pishnayim. He'd be entitled to a double share. What's less clear is, what about money in the bank? When you have funds that are in a bank account, we think about it as a deposit. People think about it as, I have money in the bank. In reality, that's not true. There's no dollar that belongs to me. Essentially, when you put money into a bank account, you are lending the funds to the bank. It's owed back to you. Now, it's collectible at any time. The bank is a very secure borrower. You have a lot of confidence that they'll pay. And if not, the FDIC stands behind them. But at the end of the day, it is a loan. It is an obligation the bank has to the account holder. And therefore, the argument can be made, the Bechor would not get Pishnayim for money in a bank account. It's only a hard asset. Now, you can, if you have a Jewish bank, things get even more interesting. Jewish banks, we all know there's an issur of ribis, cannot charge interest. They have a heteriska. If you've ever actually read through a heteriska, what it says is that half of the deposit is a loan, which a loan is not subject to Pishnayim. Half of it is a pikadon, where the bank holds this money and invests it on your behalf. A pikadon is something which is considered a muchzik, although you're not physically holding it, but if it's yours, then it should be subject to Pishnayim. So arguably, if you deposit money in a non-Jewish bank, the Bechor would not get his double share in any of the funds. It's all a loan. On the other hand, a Jewish bank that operates with the heteriska, the Bechor would get his double share on the Chelek HaPikadon, not on the Chelek HaMilva. Now, in truth, this analysis can get a little bit more complicated, and that is, what is the bank doing with your Pikadon? Banks lend money. That means your Pikadon was in turn given out to another borrower with a heteriska. which half of your bikadim then turns into a loan to the bank's borrower. So again, I don't want to get too far into the weeds, but really what should come out is that a deposit in a non-Jewish bank has no pishnayim. A deposit in a Jewish bank with a heteriska, there would be pishnayim on 1/4 of the deposit. Now, and this is just a good. It's true. You would have to make adjustments for reserves. You'd also have to make adjustments for non-Jewish borrowers. So this is a good example of if a bechor takes his brothers to a din Torah, which again I'm not advocating, but if that does happen, and you get a psak where the bezdin gave the bechor an extra 3.76% of the assets, and you walk out like, how could the bezdin do this? They don't know simple math, pishnayim. Halacha is a little bit more complicated than that, and especially in today's world. So this is the idea, the concept of bechor, of pishnayim. What he does get his double share and what? Okay, so stocks are arguably should be a partnership. If we view stocks as a great partnership, where when you own a share of Microsoft, you own 1/1,000,000th of the company. So to the extent that you own a company, that is something which is, a shutfis, is muhzik, no one owes you anything, and therefore, in a simple understanding of stocks, there should be a pishnayim. Where things get more complicated is really twofold. They're open on Shabbos. They're charging interest. How can you own stocks of any company that's engaged in Devarim Ha'asurim? And the answer is that people are samech on the famous Igros Moshe, Evan Eversim, and Dayan, that writes that when you invest in a public company and you own a de minimis amount of shares, he says that's not a true partnership. You're just buying the rights to future dividends, capital gains, whatever it may be. You're not a real partner in the underlying asset, and that's why you don't have to worry about the machlokes, asuros, isurei hano, or any of the underlying yisurim these companies are being over. Now, if we take that analysis to the end, that you are just buying the rights to future dividends, that's roy, and then there should be no pishnayim. So if we being samech on Rav Moshe and saying I don't have to worry about Shabbos, Ribbis, Tarifus, or anything because I don't really own the company, I just have rights to their profits, then in the same token you shouldn't be entitled to a pishnayim. Rav Chatzkel Roth actually has a little bit of a different outview, and he says roy means a debt that you're going to collect. Stocks which are the stock itself is traded, he says, would be different. Again, if it's not complicated enough, I'll just add that if you have a margin account, the stocks that you think you own may not exist. Your brokerage can short sell them and can sell and can lend them out. You have no idea whether your stocks are actually there, and there's no real way to track it. And this is again, it's another example of how if someone dies without any sort of estate planning, and Bezdin has to sort out what pishnayim is, it's a nightmare because there are so many detailed and intricate questions that it's just impossible to really.
One more question. What real estate? Real estate, the person leaves it over, but he really doesn't own the bank owns it. He has a mortgage on it. Somebody leaves over 10 apartment buildings, but he doesn't own them. The bank owns it.
I would argue that when you have an asset and you take out a mortgage, it's yours. There's a shibud nechasim. There's some sort of debt. I mean, I don't know what state you're from. There's the lien theory and title theory of mortgage, but today most states it's really just a lien against the asset. It belongs to the owner. So I don't think that analysis would be correct. So this is the default Seder HaYerusha. Now, if I had to hazard a guess, people in this room, I hope each and every one of you has a will. Probably it is not consistent with this Seder HaYerusha. And this raises two questions. The first point is it highlights the danger of a person that does not write a will. Because if a person dies without a will, as a matter of halacha, what happens to the assets? They get divided the way I just described it. As a matter of law, what happens to the assets? It follows a whole different set of rules. There's no idea of pishnayim, there's no bechor, there's no priority for a son over a daughter. None of this exists. which means that what you'll have is a terrible situation. You'll have a situation where in halacha the asset will belong to one person. Legally, the judge will distribute it to someone else. One of two things has to happen. Either the legal beneficiary has to have the gevuras hanefesh and the presence of mind to say, you know what, I'm not entitled to these funds, and go ahead, and the sister going ahead and give over her entire Yerusha to her brother, who is the halachic Yerush. The alternative is they can be thieves. They can keep the money that they're legally entitled to, but as far as halacha, it's not theirs. It's simple gzela. And the ones that, if you're not a Yerush and you're keeping these funds, you're simply robbing your brother, son, whoever it may be. And the tragedy is that many people work for substantial amounts of their lives because they're concerned about the future generations. They want to make sure that after their death, their family is provided for, and they want to leave over as much as they can. And all too often what can happen is, without planning, every extra dime that you've earned is just making one of your children into a bigger ganav, into a bigger gazlan, which is just tragic on so many levels. And it's easy to be avoided. A person writes a will, a tzava, he can take care of it. But if he does nothing, that he's creating a terrible, terrible nisayon for his family, and just really, really creating what could be a tragic situation. So a person decides he wants to change the Seder HaYerusha. He wants to provide for his wife, he wants to provide for his daughters. Is one allowed to do that? Perhaps the Torah says this is how the Yerusha should be divided. Perhaps that's how it ought to be divided. Do you have the right to go ahead and change that? In other words, the question is, when the Torah says a Seder HaYerusha, is this just the default? If a person does no planning or has no will, we have to have some way of dividing it. So the Torah says do it like this? Or is it more than that? Or is the Torah saying this is the way it ought to be done and it should not be changed? So this is actually a Mishnah. The Mishnah tells us in Bava Basra, if someone writes his assets to strangers and forsakes his children, what he did, if it's done appropriately and with the correct kinyanim, which we'll discuss a little bit later, it works. Person who has assets, he has the halachic ability to do with it as he chooses. Nevertheless, the Mishnah writes, Ein ruach chachamim noichi imenu. Chazal are not happy with your actions. And the Mishnah is making it very clear, the Seder HaYerusha is more than just a default. It's more than just, okay, we have to do something with the assets. It's what the Torah wants. And if a person changes it, he has the ability to do so, but it's not the right thing to do. Now, the Ramah actually brings down a fascinating Mordechai. A woman on her deathbed, she didn't realize she was dying. Her close friend was in the room. She hands the friend a sack of gold and says, do the best thing possible with this bag of gold. And with those words, she passed away. So if you were in that room, what would you do with this sack of gold? Give it to your favorite tzedakah, yeshiva, shul, find a worthy cause. Zok the Mordechai, no. You know what you do with gold? Give it to the Yarshim. And it's very simple proof. When a person dies, the Torah doesn't say the Kohen comes, takes the money and gives it to the Beis HaMikdash. The Torah doesn't say it all goes to yeshiva or to shuls. The Torah says it goes to the Yarshim. So if that is the ratzon of the Torah, then in this case as well, what this friend should do is distribute the assets according to the Seder HaYerusha. Now, based on this, it seems like all of the estate planners are in big trouble, because the Mishnah is saying it shouldn't be changed. So this leads us to the famous shita of the Iter. The Ktsayis quotes an Iter that says the following chiddush. Zok the Iter, that it's true, the Mishnah says you shouldn't be cutting out your child and giving the assets to a stranger. Zok the Iter, that's when you're completely disinheriting a Yerush. Zero. He's cut out, he gets nothing. On the other hand, he says, if you leave Daled Zehuvim, if you leave 4 gold coins to your Yorshim, there the Iter says you're free to do what you'd like with the rest of the estate. Now this Iter is a tremendous Chiddush, but it's a very, very important kula. According to the Iter, to completely disinherit a child, that's going to be Asr. But if you're not completely disinheriting them, you're leaving them at least Daled Zehuvim, then a person is free to go ahead and distribute the rest of his assets as he sees fit. Now, according to the Iter, this Isser would seem to be very uncommon. How many people in this room, in their wills, disinherited a Yerush? Anybody? Probably every single one of you did disinherit a Yerush. Why? Many wills, especially the simpler estate plans, have reciprocal wills where the husband and wife both write that if whoever dies first, the surviving spouse gets the entire estate. The second to die then already gets distributed among the children equally. Now, assuming the husband dies first, as a matter of halacha, what should happen to the estate? It should go to the sons. If you write a reciprocal will, what happens to the estate? It all goes to the widow. This is a simple and common case that violates this Mishnah. At that point, you are disinheriting your children. Now, although the expectation is that when the wife dies, at that point the children will receive the Yerusha, okay, that could be in a year, 10 years, 20 years. Right now, there's a Yerusha that's taking place. And right now, in such a will, you're completely disinheriting your halachic Yerusha. And therefore, this is something that should not be done. If a person is writing a reciprocal will, he should carve out Daled Zehuvim. He should make sure some assets flow immediately to his Yershim, Kafi, the Seder HaYerusha. And again, the rest of it, if he wants to leave to his wife, whatever he's going to do, we'll discuss that in a moment. But there should always be a carve-out where the Yershim, halachic Yershim, are never being completely disinherited.
If you write such a will, isn't that tantamount to giving her a gift during his lifetime?
No, because a will is not effective until death. And at that point, that's where this Havaras Nachla comes into play primarily. So this is, again, one takeaway is a simple will where the wife gets everything if she survives the husband, violates this halacha. There should be a carve-out for Daled Zehuvim. Now, how much is Daled Zehuvim? This is not very clear. Rav Moshe writes it's an amount that has some chashivos. You can't just say, I'm giving my Yershim 25 cents. It has to have some level of chashivos. He has 3 tshuvas, and one tshuva that Rav Moshe says $1,000 is enough. The other time he says it should be the house. The other time he is about a third of the estate. It's hard to know exactly what the cases are, how big or how small the various estates were. Rav Ullman has a tshuva where he writes that Daled Zehuvim, if a ksuba is 200 zuz, and that is the living expenses for one ani for 1 year, Daled Zehuvim essentially is how much a pauper would need to survive for 1 week without his family, which Rav Ullman writes $100 is sufficient. I guess this was written a long time ago, before COVID inflation. But be that as it may, it's an amount that has some level of chashivos. Certainly should not be enough that will cause a machlokes, but should have a certain amount of chashivos. It shouldn't be, it shouldn't be an insignificant amount that's a rounding error. Again, it's hard to give exact numbers, and it may depend on the size of the estate. This leads us to the next question. The Iter says as long as you carve out Daled Zehuvim, this Isser does not apply. Many places can argue. This is a tremendous machlokes. What is the halacha l'maisa? Is it appropriate to go ahead and change the Seder HaYerusha or not? So what many achronim say is it depends why. It depends why. If the reason why you're changing the Seder HaYerusha is that we just started this year explaining that halacha, a widow is not a Yerush, but she gets supported by the estate. Today, it's very impractical because our batei din are just not set up to service this kind of arrangement. What it means is the assets will belong to the estate. Someone's in charge, giving her mizainis, monitoring to make sure she's getting what she's entitled to. If the money is not there, selling off the assets in order to support her lifestyle. You obviously have to have a judgment call exactly how much that lifestyle is. For a woman today to have to go to her children every time she needs to buy food or pay her rent is very, you can imagine. It's very, very challenging and not so practical. So if a person says, I want to accomplish what Chazal wanted, I want to ensure that she lives in comfort and in dignity, and therefore I'm going to leave the Dal Zehuvim, but everything else I'm going to leave to my wife so she can be taken care of, that's certainly a very appropriate judgment call. When it comes to daughters, most people do not follow the Seder HaYerusha. Most people give their daughters a share of the estate. Now, this is not a newfangled American type of approach. The Ramah brings down, there was what was called a shtar chatzi zachar. The custom in the times of the Ramah was to give a daughter half of a share of the estate. The Bechor would get a double share, the Pasha would get one, the daughters got half a share. Now, a half a share is still substantially more than what she's entitled to in halacha. So the Achrayim explain, either they're relying on this sheet of the Itzur, that as long as the Yarshim are getting something, you can do what you want with the rest. Or they explain, the daughters were given this as a dowry in order to help them get married. That's one of the obligations of a parent. And that's why it became the minhag to do that. Now, once we're going down that route, once we're relying on the Itzur, or we're relying on the idea that it's appropriate to do so in order to help them get married, there's really no difference in svara between a chatzi zachar or a zachar shalim. And for that purpose, for that reason, if a person is giving his daughter a full share of the estate because of these reasons, because he wants to, as a dowry, if you will, because that's the expectation, if he's doing it to avoid machlokes, then it's certainly very appropriate to rely on the Itzur. On the other hand, if he's doing it as a matter of hashkafa, because he believes in equality, and he doesn't like this, quote-unquote discrimination, so there we have the Chazon Ish writes, to go ahead and to start saying that I disagree with the Torah's hashkafa and I want to do things differently is certainly not the appropriate approach. However, halacha l'maisa, again, when I get asked, if a person would try to follow Seder HaYerusha, he will probably have World War III break out on his kever, and it will cause tremendous destroy the family, and it's usually a very bad idea. You do not want to, although it is a machlokes, but minhag certainly is to rely on the Itzur and to go ahead and pull out a chumrah where it will cause machlokes and strife in the family. I don't think is the right place where a person should be machmer. But I'll call upon him. You just have to give it some thought. If your motivation is to avoid machlokes, great. Do what you want and come up with a plan that will work. If the motivation is the hashkafa issue of equality, then you have to be more hesitant. Regardless, there's carve-out should be the son should get at least some amount more to show that you're following the Seder Yerusha, at least the miktzas. Now, when a person is changing, playing with the Seder HaYerusha, the Gemara in Shabbos says, "Lo'olam al yishana b'ben min habanim." This is not an Isser v'Heter question. This is more a point of advice that this treating children unequally is very dangerous. Yaakov Avinu gave Yosef the Ksainis Pasim. The Shvatim, at least the simple pshat in the Chumash and Ein Mikro Yetzin De Pshutai, as a result of that jealousy, if you will, the results were a tragic galus. And the Gemara uses this as an example. Don't be so quick to go ahead and show any favoritism and give one child more than another. Now, very often people will say that one child is very successful, he doesn't need the money. The other one is less successful, and therefore I want to give him a larger share of the estate. Now, that's a very appropriate thought pattern, but you have to know your family. Some families, this is accepted and understood, and the wealthier brother will be will be generous and accommodating and accepting. Other times, I've heard people say, because my brother's a shlamazel, I have to lose out my share of the Yerusha. So you have to know who you're dealing with. You have to know your family. You have to know how it will be accepted. If you have any questions, a discussion Mechaim can go a long way. Alternatively, sometimes if you have a child that's struggling, helping him out Mechaim, helping him buy a house, very often is a way to avoid the tension. The will, they'll be treated equally, but Mechaim, one of them bought himself a mansion. He doesn't expect any parental help. The other one that couldn't afford the down payments. It sometimes is just a practical eitzah to avoid tension. So now we've gone through the default Seder HaYerusha. We've discussed a little bit about whether it's appropriate to change the Seder HaYerusha. Let's talk for a few moments about if I want to change it, how do I change it? And this leads to a very interesting question. We all know that if you want to buy something, you want to sell something, agreeing to buy, agreeing to sell doesn't have that much meaning in halacha. You can tell them you're going to buy, you're going to sell, it's still yours. You have to make a ma'aseh kinyan, some sort of formal action that actually transfers ownership of the goods. What's unique about a will or a tzava is, are you actually transferring ownership when you sign a will? No. A person should be engaging in estate planning when he's young. He's not transferring anything at that time. It's a transfer that doesn't take place until achar misa, until the person has already died. As a matter of halacha, you cannot make a kinyan la'achar misa, for the very simple reason that the moment a person dies, as far as halacha is concerned, the assets no longer belong to him. So to make a kinyan that will not take effect until after he dies is something which in halacha does not really exist. And that creates, and therefore the question is, if a person wants to go ahead and gift away assets, how can that be done? So to briefly run through some of the approaches, time is short, so I'm going to have to just be a little bit general. Some people make a kinyan on assets, a guf me'hayom peres lachar misa, which essentially means they're giving the assets today, but they retain a lifetime estate. They can use it for their entire life. But the guf, there is some sort of kinyan in the guf hadavar that happens immediately. Now, in theory, that's wonderful, but that can only work on assets that you actually own at the time you execute this will. If a person is writing a will when he's younger and he buys assets in the future, there's no way to make a kinyan on things you don't own yet. Now, what's typically done is what's known as a shtar chatzi zacher. And essentially that is, we have a problem. In halacha, when a person dies, the estate goes to the yarshim. The person wants his daughters to get a share, his wife to get a share. But we can't make a kinyan today on assets that he doesn't own yet. So a shtar chatzi zacher, which is again, the Ramah already describes this minhag, is the following. The testator creates a choiv. He says, I owe my daughter $20 million. I owe it to her now. It's not payable until a moment before I die. Now, there's a condition attached to this debt. If my sons, who are the real yarshim, give their sister a share in the estate, they treat her like a regular yarish, they give her whatever it is you have in your estate plan, then this $20 million obligation is null and void. It's a t'nai. Now, that creates a very interesting situation. As a matter of halacha, who's the Irish? The sons, the Bechor gets pishnayim, the sons get the rest, daughter gets nothing. But if the sons exercise that halachic right, what happens? The daughter comes with this paper that says that my father owes me $20 million. And based on that debt, she is entitled to the entire estate. The sons now have a choice. If they want to claim Yerusha, wonderful, then they'll lose it all because of this chayv, because of this $20 million obligation. On the other hand, if they voluntarily honor the father's wishes and give the daughter whatever it says in the will, in the trust, whatever estate documents were executed, then this obligation, this $20 million obligation is null and void and goes away. Now, most sons, even if they're greedy, know math well enough to realize this is a losing proposition. And this is a way to kind of force them to honor whatever it is it says in your will or in your trust, regardless of whether they are actually yarshim or not. So this is known as a shtar chatzi zacher. If you go to a Dayan, or today there's some attorneys that will write a halachic will addendum for you, this will essentially will be what it says. It's this way to force the halachic Yorshim to follow what it says in your estate plan. But what if you don't do that? What if a person went to his attorney, he got a secular estate plan documents, whether it's a will or a trust, whatever it may be, and did not write a shtar chatzi zachar? What is the status of that estate? So this is a tremendous machlokes. Technically speaking, we mentioned, you can't make a kinyan lachar misa. A will does not take any effect until after the person dies. And therefore, in a technical sense, the civil will, should be worthless as a matter of halacha. That being said, there are a number of reasons why many poskim hold that a legal will is enforceable in halacha. Some argue that, and this is the Moshe writes, that it's a kinyan, doesn't happen in la'achar misa, it happens b'shas misa. He has a chiddush, it happens at the moment of death, and he says that a kinyan could be done then. And therefore, the Moshe writes, a legal will is a valid kinyan. There's no reason to write a shtar chatzi zachar. The will itself is recognized by halacha as an enforceable transfer, whatever it says. Other poskim don't view it as a kinyan, but nevertheless, there's a concept of mitzvah l'kayim divrei hames, where if a person gives instructions about about his assets, there's a mitzvah to honor those instructions. Now, this is not just a nice thing to do. This is an enforceable obligation. Beis Din will force the Yorshim to follow this mitzvah, these instructions. Yeah. So they'll wait a few years, but they'll get it. Now, so why then is there a question about this? And the answer is that mitzvah l'kayim divrei hames has a number of technical requirements. It has to be hushush l'kach. The assets have to be given over to a testator, to a trustee, if you will, or an executor with these specific instructions. There are a number of other requirements which, if you look at Medina de Shulchan Aruch, a legal will does not comply with most of the requirements for mitzvah l'kayim divrei hames. Nevertheless, the Achiezer writes that these requirements are all just to show gemiras das. They're all there to show that you're serious about this is what you really want to happen to the assets. In a case where you execute a legal will, where people rely on it 100% because they know this will be probated, these instructions will be followed by the judge. So perhaps in those cases we do not need the technical requirements, we don't need hushush l'kach, we don't need the various technical requirements, and therefore the Achiezer writes that that a legal will be enforceable based on this concept of mitzvah l'kayim divrei hames. Now, as far as halacha l'maisa, it's a machlokes. If a person's father passed or parents pass away, they didn't write a halachic tzava. If someone wants to know what the right thing to do is not to make problems with your family. If this is your father's wishes, there may be mitzvah of kibbud av v'eim, there may be mitzvah l'kayim divrei hames. Rav Moshe writes it's a kinyan. What should a person do? A person should not make machlokes. A person should honor it. That being said, if you have a sibling that's not willing to do that and says, no, I want to go to Beis Din, I want to collect or I want to demand anything that I'm halachically entitled to, so then already you're on somewhat shaky ground. There are quite a number of shitos or theories why a legal will should be enforceable, but each of them are a chiddush. Each of them have other poskim that disagree with it, and therefore the outcome in a Beis Din is certainly not clear or hard to predict. And therefore, if a person has any concern whatsoever, or any thought that there's any chance there may be a machlokes lachamei v'esrim, it is certainly kedai for a person to go ahead and sit down with a rav and write a tzava, write a shtar chatzi zachar to make sure that it's enforceable in halacha. Now, a trust is actually a fascinating question because when you transfer assets to a trust, the transfer happens mechayim. The assets are, assuming it's an irrevocable trust, it's given out immediately to the trustee. So you can argue that the moment you transfer it into the trust, you've given away a matana mechayim. If it's a matana mechayim, it is not subject to hilchos yerusha, and whatever instructions are given should be followed out. On top of that, the mitzvah kaim divrei hameis, where the concern is usually that the assets are not transferred to a third party, they're not hoshesh l'kach. A trust is by its very definition hoshesh l'kach. And therefore, a trust, especially an irrevocable trust, probably is enforceable in halacha without any need for a ishtar chatzi zachar. That being said, you're not really going to find a shach that talks about a trust. This is a relatively new thing. I mean, the Gemara does talk about a kinyan almanas lahakanois, which personally I think is the same thing as a trust. But because we're not dealing with a halacha psuka, this is a more modern construct. It's probably kedai, especially if you think there might be a machlokes, to go ahead and to include it in a shtar chatzi zachar. But at least my personal opinion is, if it was really transferred to an irrevocable trust and was done seriously, I don't think that would really be subject to Hilchos Yerusha. So I'd just like to conclude with a few practical takeaways from this year, and just some practical pointers, if you will, from some experience I've had in dealing with these inyanim. The first takeaway is that if a person does not have a will or an estate plan, do something. Get something in place. Very often people are hesitant because it's not a pleasant topic, but more often because they're stuck. They don't know what to do. Their estate planning raises serious questions that very often there are no perfect solutions to. And many people just get stuck. They get paralyzed. They're not comfortable, or no solution is perfect, and therefore they do nothing. That is a disaster. Because whatever you do is better than doing nothing, having the Hilchos Yerusha kick in one way, the government weighing in a second way, and the Yarshim and the family having a third idea. So the first takeaway is, even if you don't have it all worked out, get something in place. Mirz Hashem, one day you'll come up with the perfect plan. You'll modify it. You'll modify your estate then, but do it now. The second point is that be very careful to treat everyone fairly. The Mishnah, the Gemara that says Al Yishana B'ben Bein Habanim, you have to be very, very careful if you're giving one child more than the other. It might be very obvious to you they deserve it. Your children may or may not see it that way. So if you're going to do that, again, there are cases where it's appropriate, but when the Gemara says La'olam Al Yashana, it means La'olam, and if you do want to change it, you have to be very confident that it will be perceived by everyone else the same way. It's probably a good idea to pull over some of the children beforehand and let them know. Because that leads us to the third point is, avoid surprises. If Yarshim go through their whole entire life expecting things to happen a certain way, or expecting a certain amount of affluence, and then they're you have a rude awakening after the Ptira, and they find the father not nearly as wealthy, and maybe a child that was involved in the business now owns more than they thought about, that's a recipe for disaster. Surprising them or shocking them, people are suspicious. So it's important to manage expectations and make sure people know what eventually is going to come. Now, another important point, and this is very sensitive, is sometimes it's important to give up control. When people age, they get weaker, they get more frail, and the reality is they become much more susceptible to pressure. All too often, l'psoif yamav, a person in his later years will move into one child, and at some point he will change the will in favor of that child. Now, logically, there's a very good reason to do so. If you've lived with that child, they've serviced you, they've spent money, they fed you, they took care of you, sometimes it makes a lot of sense. But at the same time, there's a lot of room for abuse. There's a lot of room for undue influence or pressure to be brought to bear. And therefore, it's important for a person, before he reaches that stage, to make plans, take steps, sometimes transferring it to a trust where you no longer have the control is a tremendous safety valve. It protects you from the pressure and protects the children from any suspicions of foul play, because any change that was made was done by the trustee, it was done by someone who was not susceptible. And again, regardless of whether someone does or doesn't do anything, it just removes that suspicion. Another point to keep in mind is that when no one likes thinking or planning about their death. Today, we're focusing on the financial aspects of estate planning and some of the reasons why inside Hilchos Yerusha it's important to plan. But there are a host of other reasons, and there are a host of other considerations to take into account. When you go to an attorney, besides working out an estate plan, they will very often talk to you about a healthcare proxy. Today, we all know hospitals kill people. The value of life in the secular world and the value in life in halacha is drastically different. And if a person has no healthcare proxy, to a large degree, he'll be at the mercy of whichever intern may be on call at the moment of the emergency. If he has a healthcare proxy that sets forth his wishes, the organization that he wants to be in charge of things, it can literally be a difference between life and death. The same thing is true about having, some other practical matters is having a power of attorney. When a person is incapacitated, to make your family in that time of stress, to go through the legal hoops in order to get his affairs in order, the last thing they need at that point is not being able to access a bank account to pay for any bills. Having your affairs in order, having a power of attorney, making sure you have sufficient life insurance to take care of the family. There are a lot of practical matters that when you sit down and work out your estate plan, a lot of other things that will be addressed. And in conclusion, just want to add one additional thought, and that is very often as a Dayan, I'll get a call from a parent. They're working on their estate plan, they have their attorney, they have their ideas, but their concern is that what will be with the family? What will be with machlokes? Everyone has heard horror stories about Yerushas that have ripped apart families. Now, parenthetically, I'll tell you that is very rare. The overwhelming majority of Yerushas get settled friendly and amicably within the family. It's a minute percentage that blow up, but any one that happens is a tragedy. And parents are often very concerned, what can I do? What documents can I put in place to minimize that? And what I often tell them is that if you've lived your entire life of greed, if children grew up fighting for every dollar, and if from your behavior they learned what it means to fight for every dime you're entitled to, there's nothing a Dayan can do with a document to make up for 70 years of failed chinuch. It just can't be done. The role model that you were, the behaviors that you looked up to or aspired to be, are really what's going to impact your children. One of the saddest meetings I've ever had is I dealt with a Yerusha case. It was a fight. Everyone meant well, was being erlich, but it was a little bit more nasty than it needed to be. Ultimately, it was resolved. 5 or 6 years later, the side that had actually prevailed came to me with his children, and essentially this person had realized that he had just gone through a fight with Hilchos Yerusha. What's going to be when he passes away? And in that short meeting between him and his children, it was very apparent that when he died, there was going to be World War III. There was going to be a machlokes. And the tragedy is that this is his own doing. His children had seen how he dealt with his Yerusha dispute. They saw and they learned all too well what their father's values were. And there was little question that was going to propagate to the next generation. And therefore, if a person goes ahead and adarabah, he lives a life where his children know being erlich is more important than being wealthy. His children know that shalom is more important than having the last word and getting the upper hand. And they absorb those values, and they see the importance of shalom and the tragedy of machlokes. So if you've seen that, I tell them, my services you don't really need. And if they've really absorbed those lessons, then forget about the estate. You've left them with a treasure worth more than gold and silver. Thank you.
Shem irgendwelche term, was ist posting like to give you a shikayach to Rabbi Marburger for tonight's share. Have the great schus of sponsoring a share or to inscribe Irgun Shir Torah into your estate plan and your will, call Irgun Shir Torah at 718-851-8651 or email ist@yeshivanet.com. Also to put an ad in the dinner journal, the occasion of Irgun Shir Torah's annual dinner coming just up in just 2 weeks to honor any of the Rabbanim whose shiurim you've enjoyed. To have a chelik in Abatzas Torah, the Rabbim of Irgun Shir Torah worldwide throughout the year. Call Irgun Shir Torah at 718-851-8651 or email ist@yeshivanet.com. I'd like to give big shekayach to Rabbi Ari Parnas, one of the board members of Irgun Shir Torah, for sponsoring tonight's shir. I'd like to give big shekayach to the Lowinger family for their support for tonight's shir. Lila Nishmas Isha Mindel Bas Rabashaleh Sholem. I'd like to give big shekayach to Mr. and Mrs. David Lang for their support for tonight's shir. Lila Nishmas Isha Chana Bas Rabitza Galiyazah Sholem Bas Year. Regular Shloishim, Tanish Masem Truas B'Sar Chaim. Ashikar to one for coming of Chananya ben Akasha Omer. Rotzak Kadosh Baruch Hu Lazakes Es Yisrael Afikir Hiblim Torah Mitzvah Shenema Alonoi Chofes Eman Tzidkoi Yagdul Torah V'Yader.